आबाद रहे वो गाँव मेरा जहाँ लौट के वापस जा न सका। ओ वतना बे मेरे वतना बे तेरा मेरा प्यार निराला था, कुर्बान हुआ तेरी अस्मत पे मैं कितना नसीबों वाला था। तेरी मिट्टी में मिल जावा गुल बन के मैं खिल जावा, तेरी नदियों में बह जावा तेरे खेतों में लहरावा, इतनी सी है दिल की आरज़ू।
So I would like to request now Dr. Shubhamay Kisku to introduce our first speaker, Professor Manik Chakraborty.
Thank you, Professor Bagchi. Good evening, all. It is an immense pleasure for me to introduce Professor Manik Chakraborty. He is former professor and head Department of Law, University of Burdwan. He is quite experienced in handling various academic administrative duties. He was director, UGC Academic Staff College, Burdwan University. He was controller of examinations in the same university. He was also attached with Amity University, Kolkata as an advisor of Amity Law School. Professor Chakraborty has a long illuminous teaching experience of 35 years. His contribution in the academia is commendable. He has published 3 books and 40 research articles in various research journals out of his own capacity. Professor Chakraborty has produced 17 PhD scholars. Apart from this, he is a member of many PG Board of Studies in various educational institutions like Guwahati University, Raigat University, Vidyasagar University, Gaurbanga University, and Patna University. He is an expert member of Human Rights Study appointed by the UGC. Presently, Professor Manik Chakraborty is teaching as visiting faculty in PG Human Rights in the Department of Anthropology, University of Calcutta. So this is a very brief introduction for Professor Chakraborty. I request him to enlighten us with his deliberation on the legal aspect of the farm law in India. Over to you, Professor Chakraborty. Thank you.
Good evening, ladies and gentlemen. Welcome. I welcome you all in this webinar. Today it is the 159th birth anniversary of Swami Vivekananda. So first of all, I pay my regards to Swami Vivekananda before starting my discussion. And also my heartfelt thanks and congratulations to the Kolkata Study Circle for organizing such an important webinar on a debated topic, that is farm laws, existing farm laws. And so I feel it is an honor and privilege to speak in this occasion before the August gathering. Ladies and gentlemen, as you have heard and you have seen in the media, thousands of farmers are at the Delhi border with over 40 unions, farmers' unions, threatening to intensify their month-long agitation across the country if the government does not repeal the 3 farm laws passed by the parliament in the last monsoon session. As you have heard from Professor Subrata Bagchi that I've been assigned to discuss the laws only. This is my part. So as the whole debate is, now concerned with these 3 laws passed by the parliament, So I will try to discuss the provisions of these laws and also their background, how these laws have come and introduced by the government. Several petitions, as you have heard, are already filed before the Supreme Court of India. While some of the pleas sought the removal of the protesting farmers camping around Delhi borders, surrounding Delhi, and others challenging the validity of these laws. Today, as we have seen that already 8 rounds of discussion talks between the protesting farmers and the government held, and it has been failed miserably to reach any consensus. And finally, the Supreme Court of India has come to the scene to mediate the whole thing. And today in the media we have seen that a bench comprising 3 honorable judges headed by Chief Justice of India, Justice S.A. Bobde, they have suspended this implementation of these 3 laws, and at the same time set up a committee to discuss the whole issue with the farmers and to settle down the impasse. Now, a set of questions have been filed with the Supreme Court, challenging the competence of the union government to legislate on matters which are fundamentally state subjects, as we have found in the Indian Constitution. Now, can the union government violate the constitutional mandate and also the objects of the framers of the Constitution while they are making a law? This is a big question before the Supreme Court of India now. Now, here I must say that I already have heard that 3 laws have been passed by the Indian government in the last monsoon session. These are the Farmers Produce Trade and Commerce Promotion and Facilitation Act, the Farmers Empowerment and Protection Agreement of Price Assurance and Farm Services Act, and the Essential Commodities Amendment Act 2020. Now, of course, these laws came in the month of June as a 3 ordinances before being approved by the Parliament during the monsoon session by a voice vote. The government has presented these laws as reforms on agricultural system. Now, it is important to note here that government has been arguing that these 3 laws open up new opportunities for the farmers so that they can earn more from their farm produces. According to the government, key provisions of the new farm laws are intended to help small and marginal farmers who constitute 86% of the total farmers in India who don't have means to either bargain for their produce to get a better price or invest in technology to improve the productivity of the farms. Now, the government also has said that the new laws will help to strengthen basic farm sector infrastructure through greater private investments. Now, here I want to remind you that till last year, the sale of agricultural produce could occur only at the market year, that is mandis of the agricultural product market committees, APMCs. And these APMCs are regulated mainly by states through them, through their adoption of Agricultural Produce Marketing Regulation Act. During 1960s and 70s, most of the states in India, they have enacted and enforced this Agricultural Produce Markets Regulation Act. All primary wholesale assembling markets were brought under the ambit of these acts. Well laid out market years and sub-years were constituted, and for each market area, an agricultural produce market committee was constituted to frame the rules and enforce them. Thus, the organized agricultural marketing came into existence through regulating markets. By establishing this APMC, the state government wanted to safeguard the farmers from exploitation by large retailers. Now, as we know, these farm laws have been rejected by the farmers' union, as they believe that the creation of the private mandis along with the APMCs will drive agricultural business towards private mandis, ending government markets, intermediary systems, and also APMCs. As a result, big corporate houses will overtake markets, thereby procuring farm at incidental rates. Thus, they are demanding the repeal of these laws, and instead they're demanding for a comprehensive act on minimum support price all over India and for all crops. Now, here I must say that in India, the history of agriculture produce market regulation, that program dates back to colonial era, where raw cotton was first produced to attract the attention of the British administration. The rulers wanted to make available the supplies of pure cotton to the textile mills of Manchester in UK at a reasonable prices. As a result, in the year 1886, the first regulated market under Hyderabad Residency Order was established, and in 1987, the first law in India, the Bearer Cotton and Grain Market Act, was passed by the British government. The Act empowered the British resident to declare any place in the assigned district a market for sale and purchase of agricultural produce and constitute a committee to supervise the regulated markets. The Act soon became the model for the enactment in other parts of the country as well. Now, here I must mention, in 1928, the Royal Commission on Agriculture recommended setting up of regulated markets to improve the trade practices and to establish market years in the country. In pursuance to that, the Government of India prepared a model bill in 1938 and circulated to all the state governments, but not much headway was made till the independence. Now, prior to independence, here I must mention the major concern of the government policy related to agricultural marketing was to keep the prices of food for the consumers and agro raw materials for the industry to check. However, after independence, the whole scenario has been changed. Now, after independence, the need to protect the interests of the farmers and to provide them incentive prices to augment the production of agricultural commodities was also felt. Recognizing the defects like losses to the farmers in terms of undue low prices, higher cost of marketing, considerable physical losses of the produce in the agricultural marketing system, which the farmers had to face, the government, with a view to establishing a mechanism to monitor the market conduct, many states enacted the Agricultural Produce Markets Regulation Acts. And of course, in 1961, the Punjab government, they enacted the Punjab Agricultural Produce Markets Act 1961, which was followed by the Haryana government in 1961. And so far the West Bengal is concerned, as we have seen, the West Bengal Agricultural Produce Marketing Regulation Act was passed in 1972. And the West Bengal Agricultural Produce Marketing Regulation Rules was passed in the year 1982. Though, of course, the Act was subsequently amended in 2014, 2017, and the rule was also amended in the last year, that is 2020. Now, on 19 December 2000, an expert committee was set up by the Ministry of Agriculture under the chairmanship of Shankarlal Guru for the purpose of strengthening and developing the agricultural marketing in India. The Guru Committee made several recommendations, one of which included remodeling the APMC Act, already existing in India. In July 2001, again a task force on employment opportunities was set up under the chairmanship of Mantik Singh Aurelia. The task force made several observations, of which one was to repeal the Essential Commodities Act 1955, which is very important to note here, of course. Accordingly, in the month of September 2003, the Union government drafted a model APMC Act 2003 in order to reform the APMC across the country. And under this model act, provisions were made for direct sale of farm produce to contract farming sponsored from farmers' field without the necessity of routing it through notified markets. All the states were directed by the central government to amend their existing APMC Act on the line of this model APMC Act made by the government, Union government. Now, here I must mention the second report of the National Commission of Farmers, chaired by M.S. Swaminathan, also clearly proposed that the APMC Act in different states and union territories needs to be amended immediately on the lines of the draft of the amended APMC Act circulated by the Government of India, so that private sectors may invest for the development of agricultural marketing. Now, here, according to this commission, the role of the government should be only that of facilitator. Now, here I must say, the model APMC Act, which was drafted by the Government of India, it provides for direct sale of farm produce to contract farming sponsors. And at the same time, it provides for setting up special markets for perishable goods and permits private persons, farmers, and consumers to establish new markets for agricultural produce in any area. It replaces licensing with registration of market functionaries, which would allow them to operate in one or more different market areas. It provides for the establishment of consumers and farmers markets to facilitate direct sale of agricultural produce to consumers. Thus, if we go through this model act, then we'll find that the model APMC Act provides freedom to the farmers to sell their produce directly to the contract sponsors or in the market set up by the private individuals, consumers, or producers. Here, I must mention again that in the year 2019, the Ministry of Agriculture set up a standing committee under the chairmanship of Hukumdev Narayan to review the loopholes of the agricultural marketing and also the role of weekly Gramin Haats. After going through the report of this committee, standing committee, it is found that the committee straightway observed very clearly that scarcity of marketing platforms for agricultural produce and management and corruption in APMC markets have created a situation where farmers are being deprived of fruits of their hard-earned labor, leading to the low price realization for their farm produce. So, accordingly, the present India government last year in the month of September 2020, enacted these three farm laws and amended also the Essential Commodities Act 1955. Now, let me discuss these three existing laws, farm laws, what they are. Then I will come to the legal questions, those who have found before us. First of all, I must mention here the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. In the very preamble to this act, it has been clearly mentioned, this is an act to provide for a national framework on farming agreements that protects and empowers farmers to engage with agribusiness farm processors, wholesalers, exporters, or large retailers for farm services and sale of future farming produce at a mutually agreed remunerative price framework in a fair and transparent manner, and for matters connected therewith or incidental thereto. Now, if we go to the provision of this act, then here I have seen that farming agreement, that is very important to note down here, which has been mentioned under section 2, clause G. Farming agreement under this law means a written agreement entered into between a farmer and a sponsor, or a farmer, a sponsor, and a third party prior to the production or rearing of any farming produce of a predetermined quality, in which the sponsor agrees to purchase such farming produce from the farmer and to provide farm services. So, for this purpose, the term farm agreement may include trade and commerce agreement, where the ownership of commodity remains with the farmer during production and he gets the price of produce on his delivery as per the agreed terms with the sponsor. Production agreement, where the sponsor agrees to provide farm services either fully or partially and to bear the risk of output, but agrees by such farmer, and such other agreements or a combination of agreements specified above. Now, farm produce, the term farm produce, rice and wheat, it mentioned here in this act, actually, it has been defined under section 2, subsection H, farm produce, which includes foodstuffs, including edible oilseeds and oils, all kinds of cereals like wheat, rice, or other coarse grains, pulses, vegetables, fruits, nuts, and spices, sugarcane, and products of poultry, piggery, goatery, fishery, and dairy intended for human consumption in its natural or processed form. Cattle fodder, including oil cakes and other concentrates, raw cotton, whether gained or ungained, and cotton seeds and raw jute. So these are now included within the purview of the term farming produce. Now, next, let us come to section 3 of this act. Section 3 of this act clearly mentions a farmer may enter into a written farming agreement in respect of any farming produce, and such agreement may provide for the terms and conditions for supply of such produce, including the time of supply, quality, grade, standards, price, and such other matters, and the terms related to supply of farm services, provided that the responsibility for compliance of any legal requirement for providing such farm services shall be with the sponsor or the farm service provider, as the case may be. And no farming agreement shall be entered into by a farmer under this section in derogation of any rights of a sharecropper, that is, rights over the land. Now, the minimum period of farming agreement shall be for one crop season or one production cycle of livestock, as the case may be, and the maximum period shall be 5 years. For the purpose of facilitating farmers to enter into written farming agreements, the central government may issue necessary guidelines along with the model farming agreements in such a manner as it deems fit. Now, under section 5 of this act, it is mentioned the price to be paid for the purchase of a farming produce may be determined and mentioned in the farming agreement itself, and in case such price is subject to variation, then such agreement shall explicitly provide a guaranteed price to be paid for such produce. This is very important, section 5, a guaranteed price to be paid for such produce. Now, the sponsor may, before accepting the delivery of any farm produce, they have the right to inspect the quality or any other feature of such produce as specified in the farming agreement. Otherwise, he shall be deemed to have inspected the produce and shall have no right to retract from acceptance of such produce at a time of the delivery of thereafter. Now, the state government may prescribe the mode and manner in which the payment shall be made to the farmer under subsection 3 of this section 2. Now, section 7 of this act clearly mentioned where a farming agreement has been entered into in respect of any farming produce under this act, such produce shall be exempt from the application of any state act. This is very important to note here. Again, I'm repeating, where a farming agreement has been entered into in respect of any farming produce under this Act, such produce shall be exempted from the application of any state act by whatever name called, established for the purpose of regulation of sale and purchase of such farming produce. So, in section 8 also it is mentioned, no farming agreement shall be entered into for the purpose of any transfer, including sale, lease, and mortgage of the land or premises of the farmer. And finally, I must say that under section 12 it is mentioned, a state government may notify a registration authority to provide for electronic regular registry for that state that provides facilitative framework for registration of farming agreements. And under section 13, the disbursement mechanism have been mentioned, and it has been mentioned that if there is any dispute between the farmers and the sponsor, then in that case, there will be a conciliation board which will go into the matter and solve the disputes in an amicable way. Now, let us come to the next act. There is the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020. Here it is mentioned that this is an act to provide for the creation of ecosystem where the farmers and traders enjoy the freedom of choice relating to sale and purchase of farmers' produce, which facilitates remunerative prices through competitive alternative trading channels to promote efficient, transparent, and barrier-free intrastate trade and commerce of farmers' produce outside the physical premises of markets or deemed markets notified under various state, APMC as I have mentioned, to provide a facilitative framework for electronic trading and for matters connected therewith and inserted there too. Now, under this act, very interesting here, what I have seen, that here the term person includes an individual, a partnership firm, a company, a limited liability partnership, a cooperative society, a society, or any association or body of person duly incorporated or recognized as a group under any ongoing programs of the central government or the state government. And here one interesting point I have seen mentioned by the central government, which is very unique because it was not mentioned in the earlier act, that is trade area. Trade area that has been defined under section 2, clause M, where it has been mentioned that trade area means any area or location, place of production, collection, and aggregation, including farm gates, factory premises, warehouses, silos, cold storages, or any other structure or places from where trade of farmers' produce may be undertaken in the territory of India, but doesn't include the premises, enclosures, and structures constituting physical boundaries of principal market yards, sub-market yards, and market yards, that is mandis, managed and run by market committees formed under the state APMC Act in force in India. So this is very interesting here. I must mention that as if it has been shown that this is an additional opportunities given to the farmer, because keeping APMC, mandis and all, now the government has created a new trade area and defined it almost same like market, mandi area, but at the same time, here it is mentioned that, of course, but does not include the premises, enclosures, and structures constituting, physical boundaries or mandis and all these things, formed under the state APMC Act in force in India. So this is also a point of discussion because when the farmers are very much now concerned with these mandis and new mandis or new trade areas to be opened up, then what will be the condition of the existing mandis under the APMC Act? There is a big question. Of course, we have seen that the central government many times, they assured the farmers' unions that no, these existing mandis will be there. And the government, and that will work as usual, like previous years. But besides this trade area, also new trade area will be operating as additional opportunities to the farmers. So this is a big question now. Why the central government is providing these additional opportunities while the keeping existing also mandi is also in presence. Now, again, section 3 of this act mentioned, subject to the provisions of this act, any farmer or trader or electronic trading and transaction platform shall have the freedom to carry on the interstate or intrastate trade and commerce in farmers' produce in a trade area. Now, any trader may engage in the interstate trade or intrastate trade within the boundaries of the trade of scheduled farmers' produce with a farmer or another trade in a trade area, provided that no trader except the farm producer organization or agricultural cooperative society shall trade in any scheduled farm produce unless such a trader has a permanent account number allotted under the Income Tax Act 1961 or such other document as may be notified by the central government. So this is another very important point to note down, that they must have the permanent account number as allotted under the Income Tax Act 1961. Now, the central government may, of course, if it is of the opinion that it is necessary and expedient in the public interest to do so, prescribe a system for electronic registration for a trader. So the power has been kept at the hand of the central government in the public interest here, and the modalities of trade transaction and mode of payment of the scheduled farmers' produce that in the trade area, that may be also framed by the central government under section 3, section 4, subsection 2 of this act. Now I am coming to another important section of this act, section 6 of this act. This is very important. No market fee or cess or levy by whatever name called under any state APMC Act or any other state law shall be levied on any farmer or trader or electronic trading and transaction platform for trade and commerce in scheduled farmers' produce in a trade area. So this is very interesting here. So presently what the state government is doing, earning revenue, now that has been totally stopped, because it is clearly mentioned that no market fee or cess or levy by whatever name called under any state APMC Act, the existing state APMC Act or any other state law shall be levied or on any farmer or trader or electronic trading and transaction platform for trade and commerce in scheduled farmers produce in trade area. Mind it, please mind, here mundi or all these things have not mentioned. Trade area, as I told that this is a unique term, coined by the central government when framed the law. And this particular section 6 of this act is very important because the state government is going to lose the whole revenue under this section 6 of this act. Now, again, section 7 of this act mentioned that the central government may, through any central government organization, develop a price information and market intelligence system for farmers' produce and a framework for dissemination of information relating thereto. And so far the dispute resolution system is concerned, it has been mentioned under section 8. If there is any kind of dispute with the producer, the farmers and the private sponsors, then in that case, arising out of a transaction between the farmer and a trader under section 4, then the parties may seek a mutually acceptable solution through conciliation. So the process of conciliation by filing an application before the subdivisional magistrate, who shall refer such dispute to a conciliation board to be appointed by him for facilitating the binding settlement of the dispute. So now here, so this is the second law where I have gone through. Now let us come to another most important law here, that is the Essential Commodities Act 1955. Now, see, please remember, in 1955, the government of India, this parliament has enacted this Essential Commodities Act. And under this act, the government of India regulates the production, supply, and distribution of a whole host of commodities it declares essential in order to make them available to consumers at fair prices. Under this act, the government also can fix the MRP, minimum rate, of any packaged product that it declares as an essential commodity. The center can also add commodities in this list because there is a schedule in this list where all the essential commodities, name of the commodities have been mentioned in this act, and the central government can also add commodities in this list when the need arises and can take them off the list, outside the list, once the situation improves. Now, if a certain commodity is in short supply and its price is spiking, then the government can notify such stock holding limits on it and for a specified period. So for the powers of the state government under this act, I must mention that under this act, the respective state governments can choose not to impose any restrictions as notified by the central government. However, if the restrictions are imposed, traders have to immediately sell any stock held beyond the mandated quantity into the market. And this is done to improve supplies and brings down the prices. Now, I must mention here that so far the act is concerned, if you see the section 2A, a new section has been inserted in this act by amendment, section 2A, in the year 2006, by the amendment of this act by the parliament, where it has been mentioned, for the purposes of this act, essential commodity means a commodity specified in the schedule of this act, as I have just mentioned. Subject to the provisions of subsection 4, the central government may, if it is satisfied that it is necessary so to do, in the public interest, please mind here, in the public interest, and for reasons to be specified in the notification published in the official gazette, amend the schedule, as I have mentioned that there is a schedule provided under this act, can amend the schedule so as to, in public interest, so as to add a commodity to the said schedule or remove any commodity from the said schedule, whatever we have seen now under the present amendment made by the parliament in last year. It is very important, section 2A here, because the central government has given the power under section 2A here, that it can add a commodity to the said schedule in the public interest, or it can also remove any commodity from the said schedule in consultation with the state governments, of course. Now, again, under this section 2A in subsection 4, it has been mentioned, the central government may exercise its power under subsection 2 in respect of the commodity to which parliament has power to make laws by virtue of entry 30 in list 3, in list 3rd, in the 7th schedule of the Constitution. And every notification issued under subsection 2 shall be laid as soon as maybe after it is issued before both the House of Parliament, what the central government has done in the last monsoon session of the Parliament. Now, of course, here I must mention that under section 3, it is clearly mentioned the central government is, if the central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing supplies of any essential commodity or for securing their equitable distribution and availability at fair prices, then it may, by order, provide for regulating or prohibiting the production, supply, and distribution thereof, and trade and commerce therein. Now, let us see what are the amendments made by the central government, the parliament, in the last monsoon session of this Essential Commodities Act. See, in the last monsoon session, this Act, Essential Commodities Act, has been amended. So this is known as Essential Commodities Amendment Act 2020. Here, in section 3 of the Essential Commodities Act 1955, after subsection 1, what just now I have read, then 1A, a new subsection has been added. a new subsection 1A has been added under section 3 of the Essential Commodities Act, under section 3. Now, what is mentioned here? Under subsection 1A, it is mentioned that notwithstanding anything contained in subsection 1, the supply of such foodstuffs, including cereals, pulses, potato, onions, edible oilseeds, and oils, as the central government may, by notification in the official gazette, specify, may be regulated only under extraordinary circumstances, which may include war, famine, extraordinary price rise, and natural calamity of grave nature. Now, then again mentioned here, any action or imposing stock limit shall be based on price rise, and an order for regulating stock limit of any agricultural produce may be issued under this act only if there is 100% increase in the retail price of horticultural produce or 50% increase in the retail price of non-perishable agricultural foodstuffs. This is also very important, this one. Provided that such order for regulating stock limit shall not apply to a processor or value chain participant of any agricultural produce if the stock limit of such person doesn't exceed the overall ceiling of installed capacity of processing or the. But very important to mention here, again it is mentioned here, provided further that nothing contained in this subsection shall apply to any order relating to public distribution system. Please note down this amendment. Here it is clearly mentioned under this amendment that nothing contained in this subsection 1A, which has been inserted by this amendment by the Parliament in last monsoon session, nothing contained in this subsection 1A shall apply to any order relating to the public distribution system, PDS, as Professor Subrata Babu has mentioned regarding the PDS system, existing PDS system. So nothing contained in this subsection 1A shall apply to any order relating to PDS, public distribution system, or the targeted public distribution system made by the government under this act or under any other law for the time being in force. So this is very, very important here that public distribution, so far the public distribution system is concerned, the government, the union government did not try to interfere, of course. Now, the question here, what have been challenged before the Supreme Court, so what the competence of the union government to legislate on state matters. Here, see, if we talk about our Indian Constitution, then we will see that the whole legislative powers are distributed through the 7th schedule to the Constitution, which contains, of course, a union list, a state list, and a concurrent list. Now, agriculture with all associated subsidiary enterprises, including education and research, livestock, fisheries, irrigation, etc., is a state subject. Please note down, this is a state subject. Markets and fairs are also a state subject under entry number 28 of the state list. Even a trade and commerce within a state is also a state subject under entry 27 of the state list. Now, of course, now, after an amendment to the Indian Constitution, that is third amendment to the Indian Constitution in 1954, now all these things have been now kept under the union government subject to entry 33 of the concurrent list. That, however, all these things are subjected to the entry 33 of the concurrent list. Now let us see what is entry 33 mentioned in the concurrent list. See, actually I must say that it is this entry 33 of the concurrent list which has been put to use by the central government to bring this farm acts Entry 33 in its current forms, of course, it mentioned the trade and commerce in and the production, supply, and distribution of, number one, the products of any industry where the control of such industry by the union is declared by the parliament by law to be expedient in the public interest, and imported goods of the same kind, such products. Number two, foodstuffs, including edible oil, seeds, and oils. Number three, cattle fodder, including oil cakes and other concentrates. Number four, raw cotton, whether ginned or unginned, and cotton seeds and raw jutes. Now, interestingly, as I have mentioned, that industries are also a state subject under entry 4, but with a rider that Parliament by law may declare any industry to be under the control of union government if it is necessary for the purpose of the prosecution of war, as mentioned under entry 7 of the union list, or where Parliament feels that it is expedient in public interest under entry 52 of the union list. Now, as I have mentioned, that in 1954, the Parliament has made the amendment to the Indian Constitution, which is known as the Third Constitutional Amendment Act, 1954. Now, interestingly, the framers of the Constitution put no such rider with regard to agriculture or markets. The framers of the Constitution, I must mention here, put no such rider with regard to agriculture or markets, which shows that these are essentially the state subjects. It is due to the peculiar circumstances that entry 33 in the concurrent list came to be amended by way of third amendment of to the Constitution in 1954, and the sub-entries B to E were introduced. B to E were introduced under this third amendment. B mentions foodstuffs, including edible oil, seeds and oils. C mentions cattle fodder, including oil cakes and other concentrates. And D, raw cotton, and E, raw jute. So these have been incorporated by third amendment of the Constitution in 1954. Now, there is a history and background to the third amendment by which the scope of entry 33 was enlarged. I want to discuss this before the August gathering because this is very important when this has been challenged by petitioners before the Supreme Court about the constitutionality of these enactments on the basis of this entry 33. Because there is a background to this. See, trade and commerce within the state and production, supply, and distribution of goods were the matters enumerated in the provincial list as per the Government of India Act 1935. Now, due to the Second World War, emergency was declared and the central legislature acquired the power to legislate on these matters which were in the state and or oblique provincial list. It was previously on the state list. Now, after the end of the war, it was lifted on 1st April 1946. However, the power to legislate on these matters was sought to be retained by the Dominion government due to prevailing circumstances and scarcity of essential items. For this purpose, then, the British Parliament enacted the Indian Council Government and Legislature Act 1946, permitting the Dominion government to legislate on certain state subjects. And in addition to it, the Dominion government also enacted the Essential Supplies Temporary Powers Act 1946, which has been replaced by the this particular law, that is the Essential Commodities Act 1955. Now, these two enactments were to operate for a period of 1 year, but the lives of these enactments were extended from time to time. The Constitution of India came into effect on 26 January 1950, and the Constituent Assembly, with a view to carry on with this arrangement, whereby the Union government could legislate on certain matters within the state list, inserted Article 369 in the Constitution as a temporary provision for a period of 5 years. Now, the lives of the Article 369 and the Essential Supplies Temporary Powers Act 1946 were to expire on 26 January 1955. However, the situation of food articles and other essential supplies in the country was still precarious, and the menace of hoarding and black marketing still existed. So, with a view to continue with the same arrangement, 4 sub-entries were introduced, as I have mentioned, in the entry 33 by way of a third amendment to the Indian Constitution, and alongside the Essential Commodities Act 1955 also was enacted by the Parliament. Now, so what the entry 33 is concerned, see, entry 33 of the concurrent list enabled Parliament to legislate in respect of industries declared to be under union control. In addition, Parliament was empowered by Article 369 for a period of 5 years to legislate in respect of certain specified essential commodities. Now, it was not considered advisable that after Article 369 lapsed to control the production, supply, and distribution of some of these essential commodities. It is not advisable. So the bill seeks to amplify entry 33 of the concurrent list accordingly. Now, thus the amended entry 33 and the Essential Commodities Act principally equipped the union government to tackle the scarcity of essential articles, hoarding, black marketers, and additional price rise, among other things, in the country, and were never meant to be used in a general situation. The Parliament at the time of carrying out the third amendment could well have created a separate entry in the concurrent list, but it was not done. Rather, foodstuffs and other items were grouped with the existing item in entry 33, which also indicates that the intention of the Union legislature was to resort to these entries only in exceptional circumstances. Now, the interpretation which the present Union government given to entry 33, this is very interesting, of course. The Union government has tried to it as a standalone provision, and it conveniently ignored the context, object, and historical background, and also, I must say, the intention of the framers of the Constitution when it was inserted, and also the framers of the legislators, the laws, when it is inserted in the entry 33 of the Indian Constitution. Now, with the Farmers Produce Trade and Commerce Promotion and Facilitation Act, the center seeks to control of the entire intrastate sale and purchase of all the agricultural produce, and has stampled upon the entire space, which is otherwise a domain of the state governments. This is very important. Now, here lies of course, the actual interpretation of the entry 33, because it is clearly mentioned that the intention of the Union legislature when it was inserted, it was to resort to these entries only in case of emergency circumstances or exceptional circumstances. But now the question remains whether in 2020 there was any exceptional circumstances when the government had to take resort to these provision. Now, secondly, Section 6 of this Act, the Farmer Produce Trade and Commerce Promotion and Facilitation Act, Section 6.
Professor Chakraborty,
Yeah.
I have a humble request. Could you please finish it within the next 5 minutes?
Just 2 to 3 minutes, I'm finishing.
Thank you.
So Section 6 of the Act, of this Act, as I had mentioned, the Farmers Produce Trade and Commerce Promotion and Facilitation Act, Section 6, it lays down that the state will not charge any market fee, cess, or levy on the trading of farm produce. This is again a clear encroachment on the domain of the states. So, entry 33 deals only with the trade and commerce of foodstuffs and other items, and permits no such interference that the central government can legislate on the subject of market fee, cess, or levy, much less prohibit the state from levying the same. This is very important to know. And as I have mentioned, no term such as trade area already we can find in the Constitution. The power to legislate on markets and fairs is only with the state governments under entry 28 of the Constitution. So the Union government cannot whittle down the legislative sphere of the states, nor can entry in the 7th schedule be overridden or rendered otherwise by merely enjoying different terminologies. Now, it is very important to note that the whole now case is pending before the Supreme Court. And of course, the Supreme Court, in the light of the known principles of interpretation, can apply the principle of judicial review and take a decision. But however, the Supreme Court has taken the process of amicable solution, as you have seen today, by setting up a committee. So now we have to watch and wait for the whole thing, what comes next. So with these words, thank you very much. I'm grateful to the organizer for giving me this opportunity to discuss with the August gathering my ideas on these 3 laws mentioned by passed by the Parliament. So with these words, thank you again. Thank you very much. Namaskar.
Thanks a lot, sir, for enlightening us about the legal aspect of the farm law in a very lucid manner. In your deliberation, it is elaborately discussed about the history of the APMC Act. It is clear that how the farm law has been evolved in India since from the colonial era. It is also understood that after the independence of India, it was tried to protect the interest of the farmers by the government of India. You have also talked about the different loopholes of the Act. From your deliberation, we have come to know about the constitutional framework of the laws. It is also understood from the speech that how the existing 3 laws has been enacted by the Parliament of India. We have minutely discussed about different sections and amendments of the laws. Finally, you have dealt with the legalities of all these laws and role of the Supreme Court in dealing with the present crisis. Thank you once again, sir, for making you available for this webinar.